that I didn't get to know Isabella while making the movie because we met a couple times, but we weren't working together.
Yeah.
And Colleen is really the one who, Colleen connected with me. But Colleen was incredible in saying, like, okay, the book is one thing and the movie also is another thing. And we have to make sure that we're not making a replica of the book if it isn't always the best and most authentic choice for the moment. And I think because of that, it's a very true adaptation of the book. Like, it is very, very, very true to the book. And
things have taken a very dramatic turn. For weeks, people have been following the unfolding drama involving Blake Lively, Justin Baldoni, Wayfarer Studios, and a long list of PR representatives. It's a tangled web of accusations, lawsuits, and behind-the-scenes maneuvering that has grabbed headlines. At the heart of it all is a lawsuit where Blake accuses her former collaborators of harassment, retaliation, and other serious claims. But the latest development could potentially sweep most of those accusations off the table. Recently, Blake filed her second amended complaint, adding more detail to her case. Not long after, Jed Wallace filed a motion to dismiss, laying out clear arguments against her claims. At that time, many observers wondered why Wayfarer didn't make the same move. Instead, they took another legal route called a judgment on the pleadings. While it sounds complicated, the idea is fairly simple. Unlike a motion to dismiss, which is filed before a defendant responds, a judgment on the pleadings happens after both sides have filed their main arguments. This allows the judge to look at the complaint, the responses, and any attached documents to decide if certain claims should be thrown out before the case even reaches the evidence-gathering stage. What's at stake here is huge. If Wayfarer's request is successful, the entire case could be reduced to nothing more than a basic contract dispute between Blake's company and the production entity It Ends With Us LLC. That means the larger accusations about harassment and retaliation would disappear. Wayfarer's legal team is arguing that Blake's case has fundamental problems. For example, some of her claims rely on California law, specifically the Fair Employment and Housing Act (FAHA). But Blake is a New York resident, and the movie was filmed in New York and New Jersey. California law generally doesn't apply to situations outside its state borders unless the legislature has explicitly said otherwise. Wayfarer points to cases like Sullivan v. Oracle to back up their argument. In short, they say California law cannot be stretched to cover incidents that never happened in California. Another key point is that Blake's complaint doesn't show any adverse employment action. In legal terms, that means she didn't clearly connect her harassment complaints to real workplace consequences, like being fired, demoted, or otherwise harmed. She also hasn't shown a direct link between her allegations of harassment and the supposed smear campaigns she claims followed. The timeline she lays out is vague, and the defense argues that her accusations don't prove retaliation under either federal law, Title VII, or California law, FAHA. Wayfarer also challenges whether Blake went through the proper administrative steps before filing her lawsuit. Usually, before suing for employment discrimination, a person must file a complaint with the state agency, in this case, California's Civil Rights Department, and get a right to sue letter. But Blake didn't include her actual employer, It Ends With Us LLC, in that filing. Instead, she listed Wayfarer and various individuals. This oversight could sink several of her claims entirely. Finally, the defense points out that many of Blake's defamation and conspiracy allegations are legally weak. They argue those claims are barred by privilege or lack the specific details needed to move forward. They emphasize that the employment contract itself was between her company, Blake Incorporated, and It Ends With Us LLC, not Wayfarer Studios. That distinction matters, because film studios often create separate companies for each project to limit liability. By trying to blur the lines between Wayfarer and the production company, the complaint may not hold up. Altogether, this judgment on the pleadings is a strategic move by Wayfarer. They are telling the court, even if everything Blake says is true, the law still doesn't support her claims. If the judge agrees, this lawsuit could shrink dramatically, leaving only a straightforward contract issue and stripping away the sensational allegations that have made it headline news. The defense is taking a two-part approach in this battle. First, they argue that California's Fair Employment and Housing Act cannot be applied to incidents that happened outside of California. That alone, they say, should eliminate all of Blake Lively's FEHA claims. Second, when it comes to the It Ends With Us production company, they point out that she never properly included it in her administrative complaint and therefore never gained the legal right to sue it. These two strategies are separate, but the end goal is the same: to cut out nearly all of her employment-related claims. The defense wants to give the judge as many reasons as possible to dismiss these counts. Even if the judge disagrees with one reason, there are plenty of others to fall back on. One of the central weaknesses they highlight is Blake's failure to show that she experienced an adverse employment action. Under the law, for either FEHA or Title VII, a plaintiff needs to prove that the employer did something harmful in retaliation for protected activity. Without this, sexual harassment claims are much harder to win because the law almost always expects retaliation to be part of a successful case. To establish retaliation, a person has to show four things: that they engaged in a protected act such as reporting harassment, that the employer knew about it, that the employer took some meaningful action against them, and that there is a direct link between the two. The defense insists Blake has not met these requirements. They stress that Wayfarer was not her actual employer and was not a party to her loan-out agreement. That contract was strictly between her company and It Ends With Us LLC. Because of this, they argue she is suing the wrong party. They also emphasize that she was never fired, demoted, denied pay, or blocked from future work. The only thing she cites as retaliation is a wave of negative publicity that came months after filming ended. The defense says that does not qualify as an employment action, especially since she was no longer working on the film. Her claims rely heavily on the idea of a smear campaign, but the timeline makes it hard for her to prove retaliation. According to her own complaint, she first raised her concerns in May 2023. The negative press did not begin until August 2024, 15 months later. Courts have already ruled that gaps of 7 or 10 months can be too long to prove a causal connection. 15 months is nearly impossible. Even if the publicity effort was seen as retaliation, the defense says Blake cannot prove it was linked to her protected complaints. They argue it was simply crisis management. With tensions on set, her refusal to appear with Baldoni at the premiere, and stories swirling online, Wayfarer and others turned to PR professionals to defend themselves. Internal text messages even show discussions about preparing for possible criticism and planning responses if she went public. To the defense, that is not retaliation, it is reputation management. They also point out that Blake is asking the court to seal her administrative complaint even though it was already shared with the New York Times. By claiming confidentiality while using it in public, she creates another weakness the defense can highlight. In the end, they say she is trying to invent a new kind of retaliation not recognized under the law. Her defamation and conspiracy claims are also targeted. KKK statements made by defense attorneys are protected by litigation privilege, meaning they cannot be used for defamation suits. And under both California and New York law, civil conspiracy is not recognized as an independent legal claim. Without the foundation of valid retaliation or harassment claims, those additional allegations collapse. Altogether, the defense's strategy is clear. They are systematically showing the judge why Blake's complaint fails at multiple levels: wrong jurisdiction, wrong employer, lack of retaliation, and legally weak extra claims. If the judge agrees with even some of these arguments, her case could be stripped down to almost nothing but basic contract issues. Civil conspiracy can only exist if there's a valid, underlying wrong, something that is already recognized by law as a tort. The defense argues that Blake Lively's lawsuit does not contain a strong enough foundation to support such a conspiracy claim. Since her FEHA claims, Her Title VII retaliation claim, and her defamation theories are all flawed in their view. There is no core, tort left to build a conspiracy around. If the underlying claims fail, then the conspiracy automatically fails too. The court, they insist, cannot invent a brand new category of liability out of thin air just to keep her case alive. The motion therefore asks the judge to throw out a large portion of her lawsuit. Specifically, they want the court to dismiss the claims against It Ends With Us LLC, the 2nd through 7th causes of action against all defendants, the 12th through 15th claims, and the civil conspiracy count. If the judge agrees, that would leave only one Title VII claim against Wayfarer, and 2 contract-based claims tied to her loan-out agreement, and the attached rider, which contains a no retaliation clause. This would completely reshape the case. Instead of being framed as a wide-ranging employment discrimination suit filled with harassment and retaliation allegations, it would shrink down to a contract fight between an actor and a film company. In that scenario, Wayfarer and the other parties would have a far simpler job defending themselves, since contract law is much more straightforward than employment discrimination. They stress that Wayfarer was not her actual employer and was not a party to her loan-out agreement. That contract was strictly between her company and It Ends With Us LLC. Because of the defense believes their arguments are strong. They point out that Blake already struggled with earlier rulings when Jed Waller successfully had his claims dismissed. Although the judge in that instance didn't evaluate every detail of her accusations, he still recognized weaknesses in her filings. If the claims don't meet the legal standards required, the judge is obligated to dismiss them, no matter how much publicity surrounds the case. Another surprising element raised by Wayfarer is that Blake never included a copy of her signed loan-out agreement in her complaint. According to Wayfarer, neither side has actually produced a signed version. They filed an unsigned copy under seal, suggesting that Blake may never have signed the document at all. If that is true, it raises a serious problem for her. Without a signed contract, her ability to sue for breach becomes questionable. The defense argues that she left it out deliberately because it weakens her case. All of this puts the judge in a very difficult position. He has to weigh whether her pleadings satisfy the law. If they don't, dismissal is required. The defense stresses that earlier discovery rulings have nothing to do with the actual merits of the claims. Discovery is about exchanging information under court rules, not deciding whether allegations are valid. Now, however, the judge is being asked to focus on the law itself, and his earlier decisions suggest he is willing to dismiss weak claims when they don't meet the legal requirements. If this motion succeeds, Blake's case could be cut down to its bare bones. Even if the judge denies it, the defendants will still have the chance to revisit the same arguments at the summary judgment stage, where they can bring in more evidence to show why her claims should not proceed. Either way, this filing represents a major turning point. What started as a headline-grabbing lawsuit filled with dramatic accusations might soon be reduced to a simple contract dispute. Make sure to like, subscribe to the channel, and share your thoughts in the comments.